Hello, everybody. I'm Eric Feil of Richner Communications. I'm thrilled to welcome you here today to the Herald Inside LI webinar produced by Richner Live, sponsored by D'Angelo Law Associates PC. This is Estate Planning 101. We're going to answer all your estate planning questions: where to start, where to end, where to do everything in the middle, things you don't know, things you might want to learn again. We are thrilled to have with us as our expert guest today, Stephanie D'Angelo, Esquire of D'Angelo Law Associates. Welcome, Stephanie.
Hi, Eric. Thanks for having me.
Oh, thank you so much. And you and I have had a chance to talk even before we got on with our fine audience today about the importance of this subject and how you can never really learn everything, go over everything too many times. But you know more than anybody the importance of starting the conversation. So as we begin here today, looking out there, I'd love to hear a little bit, as with our audience, about a little bit about your background, how you came to be in this particular practice of law, because again, it's really, really important more and more in our day and age where there are more laws to know. There seems to be more stipulations, everything kind of changes. So how you got into it, how you keep on top of it, and then we'll dive in and start helping people out.
Absolutely. Well, I started in this area of law 12 years ago. I started as a secretary answering phones, and then I graduated to legal assistant, paralegal. I went to law school, and in law school, I continued to work in this area of law focused. I also spent some time as an intern at a federal court under a federal judge. And I did a little bit of federal work otherwise, but always sticking to trust and estates. I just love the process of figuring out a puzzle and putting it together and understanding people. I really like the interaction of getting to know my clients and understanding their life and figuring out a way to make their lives more secure, protect their assets and make sure that their families are taken care of, and as well as themselves as they age and need more help. So since then, about 3 years ago, I took over the law firm and I've been handling everything ever since. And it's been a lot of fun. It's been exciting helping people.
Absolutely. And you really touch on two great things there: helping people and putting a puzzle together, because that's what a lot of this is. Each case is very individual. Yes, there are overarching things you need to understand, but it is a case-by-case personal basis. So I'd love to start with the idea of what really is estate planning. I think when many people hear the term estate planning, they think, I'm not a billionaire. I don't have an estate. I'm not living on, a mansion on the water and have a billion different stock funds. Really, what is estate planning for everybody out there?
Yeah, absolutely. I mean, certainly those billionaires need estate planning, and their estate planning is going to be more complex than the average individual. And they spend a lot more money on attorneys, that's for sure. But you don't need to have $1 billion. You don't need to have $100 million, and you don't need to have $1 million. You just need to have a bank account. You need to have, if you own a home or, a condo, a co-op, things like that. It's all an estate plan is making sure that, one, you're taken care of if you get sick, right? That's your healthcare proxy and your living will. Those are healthcare directives. So that's appointing somebody who can make decisions for you when you can't make them yourself. Two, making sure that, if you can't handle your finances because you get sick or worse, right? You go into a coma, that someone can manage your finances, pay your bills, right? It's that simple. Calling up on your behalf to Social Security or to your pension to discuss those matters, right? And that's a power of attorney, right? And then finally, a last will and testament is directs how you want things to be distributed. If you don't make a last will and testament, the law makes one for you. It's not a real last will and testament. I have to go through a completely different process in order to get control of your estate, but the law just says how it gets distributed, and maybe you want to distribute it a different way. There are also a ton of ways that we can take control over the matter and make sure that we protect certain family members throughout that process. But an estate plan is first taking care of you during your lifetime and maybe your spouse, right? And then second, making sure everything's distributed the way that you want it distributed when you're gone.
So where is the best place for someone to start? Were I to walk in and say, Stephanie, help me out, where do we begin? Do we begin with the last will and testament? Do we begin with sort of an overarching discussion? How do we start?
Yeah, if somebody comes to me and they don't have anything, right, and they don't know anything, sometimes people come to me, and there might be people watching this that have really, this is the first time they're thinking about these things, and that's perfectly fine. You have to walk into a meeting and be honest about your understanding, what you know. It's really important. I don't expect you to know anything, so it's helpful to be forthright about that. But you're going to want those comprehensive documents, which is exactly what we discussed, right? You need a healthcare proxy and a living will, so that's your healthcare directives. You need a durable power of attorney, and you need a last will and testament. Beyond that, when we go into trust and asset protection, and depending on what you have, that's more complex estate planning. But if you don't, in New York at least, if you don't have a healthcare proxy and a living will, what we have to do in order to get control over making decisions for you, if you're unable to decide who can make those healthcare decisions for you, is we have to go to the courts, and we have to petition the courts to get an order to just be able to make healthcare decisions for you, or to be able to say, now it's time for mom or dad or my sibling to pass in a way that's doesn't prolong the process of death, but keeps them comfortable, right? So that's a do not resuscitate to some degree, right? Without a healthcare proxy in the living will, it's a process. And people think, when you go to a hospital, you sign those documents. Well, those documents are, one, created by a financial institution, a healthcare institution, with attorneys who are thinking about the financial well-being of that institution, right? And it's really just for that particular stay or that particular procedure. The one you make with an attorney is a document that's durable, right? So it's effective unless you revoke it. And the other aspect of that is, when you see an attorney, the one that you make with us is, or at least with me, is one where it specifically states what you want. And so if somebody doesn't follow those requests, right, those directives, then there's room available for us to then pursue the fact that they didn't follow it, right? And that's what we want. We want things as clear as possible, so that people can follow your instructions. And then also, if they don't, there's a penalty for it, right? So first thing you do is you set up an appointment with an attorney. You can Google some of these things, of course, but a little bit of information. But set up an appointment with an attorney to discuss what you particularly need.
So let's talk about what a healthcare proxy really is, and then how that differs from a living will.
Right. So they're very different documents. Okay. They're both healthcare directives. Directives mean that it's something where it specifically states what you want and how you want it done, right? And then it must be followed, right? So it doesn't it's not like an order where it absolutely, which comes from the court, where it must be followed, right? It has to be executed properly, okay? And it has to be executed in accordance with the law in order for it to be followed. But a healthcare proxy is a document that states who you want to make healthcare decisions for you if you're unable to make those healthcare decisions yourself. So, right, if you're in a if you're in a procedure, you're having a procedure done and you're under anesthesia, right, and a decision needs to be made about that procedure, or how to handle, maybe the way that your body's reacting to that procedure. You have a healthcare proxy who can say, okay, it's give the patient more morphine, or give them something that will make them more comfortable, or yes, you can continue with the procedure in that direction. It's also for somebody who maybe isn't no longer has the capacity. So right, as we age, sometimes people, unfortunately, they have dementia or Alzheimer's or something where their mind deteriorates. So it appoints somebody when you already have the capacity, who you trust to be able to make those healthcare decisions for you. It's very different from a living will. A living will specifically states how you want to be treated when you're dying. So the healthcare proxy appoints somebody to make healthcare decisions for you if you can't make them yourself. And a living will directs how you want to be treated when you're dying, right? So that's like the do not resuscitate. Some people want to be resuscitated, but typically people tend to choose, a version of a do not resuscitate. Without either of those, healthcare professionals can't speak to your family members, right? So under New York law, your family members, your spouse, your siblings, your children, they don't have a right to just make healthcare decisions for you. And in fact, the same goes for parents with their kids. And that's something people don't realize, right? When your kids turn 18, you no longer have any right to know anything about their healthcare. Okay, so it's also important for 18-year-olds to have a healthcare proxy. So under New York law, since we're not allowed to have that information without a healthcare proxy, we execute a healthcare proxy that specifically pinpoints who we trust to make those decisions and to have that information, right?
Yeah, this is something that can evolve going over time.
Oh, absolutely. So that's the difficulty with a healthcare proxy, right? I mean, healthcare changes. I mean, the last 2 years, it doesn't feel like 2 years, but it has been 2 years since all of this ridiculous thing happened to our world, right? With COVID-19. But look at how healthcare and how it's changed, and also how it's come politicized to some degree, right? With that, you have to have a healthcare proxy and a living will that kind of is able to evolve, right? So it can't be too specific, where it's not able to keep up with technology. And the problem is with medicine and technology in general, it's always constantly changing. So you do want to readdress your healthcare proxy every couple of years at least, also if your agent's contact information, and this is a major, pitfall I see with people who come into my office who maybe saw another attorney or tried to do this on their own. Their contact information for their agent isn't up to date. Their phone numbers aren't up to date. The point of a healthcare proxy too is to be able to get in touch with the person. And people generally aren't necessarily with you when accidents or important things happen. I mean, if you're at a procedure, then they know you're in the hospital, but this is also for those time periods where you're not necessarily just in a procedure. Maybe you had an accident, maybe you've fallen unconscious at your house and you got picked up by an ambulance. They need to know how to contact your agent. So that's a pitfall. And if you are reviewing your documents, one, you should look to see that it's still, the directives are still true to what you want in terms of your healthcare. And two, that your agents are who you still want them to be. And three, that their contact information is up to date. Okay.
Absolutely. I mean, I think that you try to do everything on a rotating basis. You change the batteries in your fire alarm when you change back the clock. So, I've always sort of used that twice a year moment to check these things, particularly contact information. It's an interesting one you say that with people's emails, cell phones, contact, where you can get in touch with people, that changes so frequently. I'm always stunned when I realize that only 6 months ago, someone now has a new place to reach them, and for a very important emergency situation.
Yeah, and it's really funny too, because, even in the last 6 years now, since it is 2021, but people who used to come in 2015, they used to put the primary contact information as somebody's home phone number. But people use their cell phones now, so that's only 6 years. But a major change has occurred since then. So that's why I usually tell people at least every 5 years, you should be reviewing your documents with your attorney. But nonetheless, if you haven't done it, now's the time to do it.
Exactly. Now is always the best time to start something in that moment.
Right.
So if we could talk a little bit about the difference, then there's healthcare proxy, there's living will. What is healthcare power of attorney? And then how does that relate to, say, a financial power of attorney or power of attorney in general? I think that one of the key things for people out there in our audience, we've got a number of questions even from as they were signing up are there so many terms that sound similar yet are not, or they're related, but how are they different?
Yeah, the lawyers in my field and the like maybe the lawmakers just wanted to confuse people because there are a ton of words that are exactly the same. Living will sounds like a last will and testament. People say living trusts, they say all of these things. Sometimes it's also just state by state, and because they say it differently. And I don't know, I'm just using an example right now, but Virginia, I don't know. Then they talk to their cousins in New York and they just talk about their documents. And I think that probably plays into it here. But a healthcare power of attorney is exactly what we talked about. And there is no healthcare power of attorney. You have a healthcare proxy, and that appoints somebody with the authority, right, to be able to make your healthcare decisions. And a power of attorney is a financial document that allows someone to manage your financials if you're unable to. Now, there are different types of power of attorney. So there's power of attorneys, and I think a common one people know about, besides a durable one, which is one that allows someone to manage finances, is the power of attorney you might sign for somebody to manage a real estate transaction, right? That's technically called a springing power of attorney because the authority is only for a particular time period. It's very it's focused, and it's only for Eric selling his Garden City house, right? Okay, and that's it. That day for that time period, nothing else, and then the authority lapses after that, right? Whereas a durable power of attorney, durable means that it's effective unless you revoke it, right? So it allows somebody to manage your finances, and the purpose of a durable power of attorney is to let somebody manage your finances, and you want to pick somebody early on, right? When you have that capacity, when you really understand who you are choosing, and that person is, very reasonable, very responsible, and very respectful, right? Those are very important aspects. And if you find that somebody has any tendency to be difficult, or has some tendencies to be less responsible, particularly with their money, right, then they're not an appropriate person to appoint as a power of attorney, right? So we have to be really honest with ourselves about our loved ones, and sometimes that's hard because I always give people the example, with power of attorney versus a healthcare proxy. Sometimes our family members are doctors or nurses, right? Healthcare professionals. And so they're the perfect person to pick as our healthcare proxy, right? And maybe that person isn't comfortable with finances. That doesn't mean they're bad with it, but they're just not comfortable, right? They're not the best for the power of attorney then. And vice versa. Sometimes we have a family member who is amazing with numbers, is extremely thorough, and they would feel horribly uncomfortable making any healthcare decisions. So we just have to be realistic and honest with ourselves, right? And then also with your attorney. I personally sit here and people sometimes try to, downplay maybe the troubles they're having in their family, or their family members' difficulties that they're experiencing. Sometimes divorce. There are lots of things that come up in people's lives, healthcare issues. But it doesn't help you to be not upfront with me. It gives me the opportunity to give you more advice, and I'm not here to judge anybody. I'm just here to help you. So.
Exactly. And I think that's a really important point, that having these conversations and being able to be honest, forthright with someone who is there as an objective advisor and helper about family. And how do you go about helping people start this difficult conversation? I mean, it's not easy when you have a family. And I think the bigger the family, the more challenging it is. If they're close enough that they're in constant communication, everyone always thinks, I know better for mom. I know better for dad. I know where they would put their money. I think Bobby should get it. No, Susie should get it. No, they should split it. oh, I'm power of attorney, I have the only final say. How do you help them navigate those waters and start that conversation? Because everybody else, I think, needs to be involved, right? You wouldn't want to have me saying, here's what's going to happen if I've never spoken to anybody in my family before about it.
Right. Oh my gosh, it can be very difficult, right? It's particularly difficult. And if there's anybody watching right now who has a family who's very involved in each other's lives and managing things, you're very lucky to have people who are involved. But it can be dicey, especially with family businesses and things like that. That's where I see, the most, resistance to kind of come together, and maybe be reasonable about what's expected and what's not expected. There happens to be, usually if you have multiple kids, right, numerous kids, maybe 3 or 4, there usually is one who kind of steps up to the plate and is ready to take care of mom and dad a little bit more than the others. But that's not always the case, right? That's still somebody who's very lucky. But people fight. That's why it's important when you sit down with your attorney is to be honest and then realistic. And, it's not, in my opinion, and it can vary from person to person, of course. I don't like having 4 people as the executor, 4 people as power of attorney. It's absurd at one point, and it makes things more expensive because I have to get everybody's yes on something small. It makes things so expensive time-wise as well, besides financially expensive. I mean, but it is hard for people. That's not a difficult, simple decision to make. To say that Susie's going to be primary and Johnny's going to be secondary. But a good way to handle things is just to be honest and upfront. In my meeting, everything is confidential. So, with me, you can discuss the intricacies, but with your children or with your family, you can just discuss the facts. This is what I want and how it needs to be done. But that's a big mistake I see people make, which is just hiding things, right? And saying, the one of a classic line I hear from clients is, well, I'll be dead, so it doesn't matter. I don't care if they fight. I'll be dead. I'll be gone. Well, I have to deal with them fighting, so I'd rather them not, right? So,
Exactly.
There's no reason that people need to fight. Some people are always the type of person where they're just looking to fight and argue, and that's a personality thing, right? But we can address that in other ways in your estate plan, of course. But if generally speaking, when you're honest and open and discussing things with your family, at least they know going into the situation, right? And they can't say that's not what mom or dad wanted, or mom and dad told me something completely different, right?
Exactly. I mean, doesn't anybody watch the movies? We know that never is going to work out. That's never good. It's good for an hour and 45 minutes on HBO, but not in the real world.
Right. You'd think, but everybody has their, they think they're different. People think their lives are different, and they won't turn out that way. So, oh my gosh, it's funny though.
So going to the very beginning, I think a lot of people think, okay, at the very least, I'll start talking about a last will and testament. Where does one begin that conversation? Is it, again, myself and my spouse, myself and my family coming to you? How do you start that ball rolling?
Yeah, if you're coming for you, right, and maybe your spouse. So if you come with your spouse, just know that when you come with your spouse, the confidentiality is between your attorney and both of you and your spouse, right? So let's say, Eric comes to me and Eric, I don't know your wife's name, but I'm going to call her Anne here. Eric and Anne come to me, and later on, Anne calls me on the side and says, I actually want to disinherit Eric. I have to let Eric know that Anne is looking to disinherit him. So, the confidentiality is not a one-way street there. There's a triangle of confidentiality there, okay? So that's fine. It's typical that couples come together. It's just that you can't disinherit your spouse. There's other reasons you can't disinherit your spouse, is actually because in New York actually is the only person you can't disinherit is your spouse. They're entitled to a certain portion no matter what of your estate.
So Anne's out of luck.
Yeah, Anne's out of luck. Sorry, Anne. But typically you come, you sit down, and it would be you coming to the attorney and discussing your matter. If it's for your parent, it's best if your parent is alone at the meeting, or you sit outside. If you need to be involved in the meeting because of physical disabilities and things like that, that's fine. We can make allowances for that. But it can be tricky, so we have to be upfront about how it needs to be addressed, and I need to hear about these things prior to our sitting down and meeting. Did that answer your question?
Yes, no, absolutely. Now, as far as what goes into a last will and testament, again, we've all seen the movies where I bequeath to my nephew my favorite Matchbox car, and then, oh, my least favorite niece, you're going to have to handle all the ugly stuff, and then she doesn't want to. So what goes into a last will and testament? What's included? And then as a sort of part two to that, what happens if someone gets something, has to handle something in a last will and testament that they don't want, or they don't want to have to do?
Right. So I think this kind of goes into what you had just asked too. What's something you're going to discuss? First things first is you got to think about who your executor is going to be. The executor used to be a distinguishing title between female or male, but so executrix is something you might have heard as well. But the executor is standard now. We don't distinguish. And that has nothing to do with the recent years where we've been kind of distinguishing genders. It's just was ease many years ago. People decided to change it. But your executor is the person who's going to be the fiduciary of your estate. So the person who kind of manages the estate and is, distributes everything the way that you want to, and has the accountability of doing that. So that's first. And again, that should be someone kind of similar to your power of attorney. Often it's the same person. It's somebody you trust, who's reasonable, who's responsible, and who's respectful, right? So you have to think of that. I always suggest people have alternates as well, okay? Because people can die. I mean, life is, there's life, there's new life, and there's death, right? You see me because you're thinking about the possibility of the fact that we're all going to pass away. So sometimes people just can't act, and exactly what you brought up just now. What if somebody doesn't want to act? I could appoint Eric as my executor, and he says, I have to do webinars. I can't act as your executor, Stephanie. So, so that's why we have alternates, people who we would want to act if that person or that our first choice can't act. And that's a great choice for people with a lot of children, right? Or a lot of family members who'd like to be involved. Alternates and structures like that. So certainly you need to know that. Another thing you need to know is who would, by law, for me personally, as your attorney, I would need to know who by law would be inheriting, right? So, maybe we don't want our kids to inherit, or we don't want our brother and sister to inherit, and that's perfectly fine. I can certainly set up your will like that, but I need to know by law who I would need to consider when I do have to probate your will, because those people technically have a right to your estate. So that goes into what we were discussing before about, avoiding fights and things like that. And then at that point, you want to know how you want your assets distributed. So first, what are your assets that you want distributed, and how you want them distributed, and to who? So that is if you want individuals, your friends, your family, your kids, your spouse, or, sometimes people come to me about distributing to charities. They want to make gifts to charities, which is wonderful. And we can certainly do that. And then we can particularize purposes. Let's say I want to give money to, the North Shore Animal League, but I want to make sure that it's specifically used for, their feline center, right? So, those are the kinds of things that we discuss and what you should kind of think about. I had a client a few weeks ago come in and they just said they wanted to give money to animal charities. So that's why North Shore Animal League's coming to mind. And they just didn't have any charities in mind. They just said animal charities, but that isn't enough, right? I need specifics. So be particular. And that's something that you'll discuss certainly during the meeting.
And I think too, it's very important, and you can speak to the nuts and bolts of this, of having the discussion, or how possible to have the discussion with family members, friends, about your plans, about your intentions, because there can be surprises. Oh my goodness, my dad really left this to them and they didn't give that to that. That can't be right, but it's in the last will and testament. Now that's done. There's no more opportunity to discuss that with dad. Right.
And, it can cause a lot of resentment for people. People get very upset about those things. And, what happens later on is, your kids who might have had a good relationship while you were alive no longer have a good relationship because, resentment. They feel hurt. And sometimes hurt comes out in different ways. It comes out as anger, and we want to avoid that as much as possible. So, for a good estate planning attorney is somebody who's thinking about not only, your client's interests financially, but also your interpersonal interests, right? So whenever somebody sits with me and starts bringing up, that they're going to distribute it in a way that is not typical, I try to mention how that might have an effect later, and maybe one that you're not interested in, right? Because we see it all, right? I see everything. I see people fighting. I see families who are perfect and they get along so well the whole entire time, and it's amazing. And then I also see people who, maybe normally they act, prior to mom or dad passing, when everything was fine and everybody was alive, they acted perfectly normal, but then their parent dies and their behavior just switches. It's like a light switch, and it's so odd to see, but it happens because, you never know how someone's going to react to death. Otherwise people just, if we're fighting while you're alive, they're probably going to fight when you're gone too,
That is true. You had mentioned earlier the term probate, and probate sounds like this big scary thing. You really kind of illuminate us. What is probate? What are the ins and outs of it? Why does it have to happen?
Right. So probate is the process of getting your will certified by the court to say that it is legitimate and that the person who's appointed as executor can now act as the representative of an estate and marshal assets, gather everything, bring it all in together, and then distribute it in accordance with that will. So it's not scary. It's much simpler than not having a will. It's a process, though. It takes time. I mean, it was certainly slowed down during COVID. The courts have, for the most part, gotten back on track, and the wait time is no longer, the months and months and months. It's still a few months, but not so bad. But it's a process, and as long as you made your will in accordance with the law and with an attorney, the likelihood is that it will be certified and probate will be successful. What you get at the end of probate is something called letters testamentary. So some people might have heard that term before, letters testamentary. So you apply for probate, you petition for probate, and then you get the will certified, and the certification is the letters testamentary saying that the executor can act. Part of what you're trying to decide when you're seeing an attorney is whether you'd like to go through the process of probate, or is it if you're trying to avoid probate. And we can do things to avoid probate. And that's how you, appoint trusts, create trusts, things like that, depending on your estate and your assets. So I like to try to avoid probate because I like to make things quick, have things done. and not wait for a court's decision. And we do that by creating trusts and appointing beneficiaries and making sure things are in order.
So let's talk a little bit about trusts. I mean, again, the trust is another one of those areas where there are a number of types of trusts. Some sound like they're the same as the next one, some are not. So if we could just start for example, I'll just throw out the term revocable living trust versus irrevocable living trust. What are these? What do these terms mean?
Yeah, irrevocable, irrevocable, tomato, tomato. That's the just so you know. Sometimes people come to me and they don't know how to say it at all. So I just let people know it's the same exact thing. Revocable typically is a trust that I refer to it as a tray. But let's step back 1 second. Trusts in general, the purpose of them is that they avoid probate. Okay, and then they also are private, whereas wills aren't private. So when I submit a will for probate, it becomes public, right? So that's why we know what Jackie Kennedy's will said. I mean, the celebrity list goes on and on, but you can look up celebrities' wills, and it's because they were petitioned for probate. Trusts keep things private. So any trust will do that. And so those are the positives of all trusts. But a revocable trust typically, and there's hundreds and thousands of different types of trusts, and they can be modified for your particular needs, et cetera. But for generally speaking, a revocable trust is a trust that it's not for asset protection, it's to avoid probate. So I call it a tray. It makes it so I know where everything's held, right? It's in my tray here. I have, maybe my Fidelity account in my tray. I have my Chase Bank account in my tray. I might have my house in my tray, and I can pass it to Eric, who's inheriting my tray, right? And I don't have to ask anybody for permission to pass that tray. Okay, I could just give it to Eric. Okay, but if somebody tries to sue me, or for whatever purpose, let's say I got into a car accident and unfortunately somebody passed away, and they try to sue me, that revocable trust is still open to creditors and liability. It doesn't protect the assets whatsoever. It's just an entity that makes it easier for me to pass things on and to manage things to some degree, right? Because the trustee of that trust can, it kind of acts like it's similar in the sense to a power of attorney, although it's not a power of attorney, it's somebody who's the trustee. So I want to make that clear. A power of attorney has no authority over a trust, but the trustee is somebody who can manage anything within the trust in accordance with the trust terms. An irrevocable trust typically has some sort of restrictions on the use of the asset, and typically also removes you, the individual who is the original owner of the asset, from the asset directly, which makes it so that that asset, depending on what you're trying to protect it for, can be protected, right? So that's the kind of trust used for such as like Medicaid protection, things like that. I know people are always concerned about look back periods, right, with Medicaid, and they are changing. In New York, right, we've always had this 5-year look back period for nursing home. That means that an asset has to be out of your name for 5 years before it's not considered yours when you're applying for Medicaid for nursing home care, okay? Right now, there is no look back period for home care Medicaid. However, January 2022, so just a few weeks away, that changes to a 2.5-year look back period. Technically, you will hear people say 30 month, it's 2.5 years. That's what 30 months equal to, right? Okay, so 2.5 years means you have to plan farther in advance, right? Before you can be sure that you can qualify for, home care Medicaid. So it's really important for you to sit down and go over your assets and think about these things in advance. But so an irrevocable trust typically has restrictions on the use of the asset, and typically separates the asset from the original owner. in a way that protects the asset. So yeah, Medicaid trusts, there are a lot of people do things like life insurance trusts, things like that. But it provides, it can provide other creditor protection as well, right? So typically, let's say I want to protect something to try to be sure that maybe that asset won't be something that can be attacked if I got into a car accident, right? And unfortunately, someone passed away. As depending on how the irrevocable trust is set up, it can do that.
So what is something like a special needs trust? Where does that fall?
Right. So special needs trust is a carve out in the law. Okay. It allows us, the government decided that we wanted to take care of our citizens who have special needs, right? Special needs is very particular designation. It's somebody who has a disability, right? The disability can range though, but you have to have a disability. And it allows us to protect assets for that individual. But the restrictions are not quite the same as, let's say like a Medicaid trust would be, because you can still use those funds for the livelihood and enjoyment of the individual who's the beneficiary in that case. But it still allows them to qualify for like disability and things like that. So if you have a kid or a family member who is, disabled physically, mentally, it's something we also can utilize for people who are experiencing substance issues. Those are all things that are really important to discuss with your attorney. And it's a lot to learn. So you got to get, you got to sit down and be willing to understand that and what you need to do as the trustee of that trust.
Absolutely. So how do you go about starting this planning early enough? We talk about the 2.5 years. So if someone's thinking, oh my goodness, I might need help in a year, they need to have really started 1.5 years ago, or what can be done immediately? How do you get about that?
Right. If they need help in a year, you better come right now, because we can get things done before January. But yeah, you should start sooner rather than later. Otherwise, typically with these kinds of things, if you're really healthy, once you're, you can, that's a good time to go, right? You want to sign your power of attorney, which requires a high level capacity, when you are completely lucid, right? You want to create your will and start protecting your assets when you're still healthy, right? There are always ways that we can manage things if people are married and things like that. There are ways that we can protect assets otherwise if we need to protect assets for our child who has special needs. But if you're an individual and it's time to start thinking about that, probably in your 60s or so. Now that we have this 2.5 year look back, I used to say 65 for irrevocable trust Medicaid planning because of that 5-year look back. But it's the 2.5 year really is a game changer here for planning. So the sooner the better. If you haven't done it, it's time to go. We can always start. I have clients who come to me in their 90s and it's their first will, and that's fine. It just limits our ability to protect your assets. But we can still make will. We can still get your healthcare proxy done, but it does limit, what we can think about in terms of your asset protection, or what we can. It's a gamble to some degree, right? Because you may never need Medicaid, right? Not everybody does. Right. The gamble is usually a lot of, it's protecting a lot of money by spending a little bit of money, and it's usually worth it, right?
Absolutely. You said just to kind of have yourself covered should that eventuality occur.
Yes.
So we've had a number of questions from our audience coming in as they were signing up. So I'd love to take some time here and get your insights and knowledge, sharing it out there. So we'll start with, here's a question that's one that I've actually heard more and more. What about my pets? How do I make sure they're going to be taken care of when I'm gone?
Oh yeah. Well, I have pets too. I want them taken care of. So I completely understand that. And it's funny because this younger generation, people are having, they're talking about how people are having their kids later in life, and they're calling their pets their children. And I've had a number of younger adults come to me to create their wills, and they just create, it's called a pet trust. So we create a pet trust, and there are certainly ways that you can create a trust that we appoint somebody as your pet's guardian, and that they have a financial incentive to be able to take care of your pet, and you also put money aside for that care. So certainly there are ways to protect your pet and make sure your pet is taken care of. I mean, that's particularly important for animals that live a long time. I have clients who have like macaws, parrots, right, that live till 100. I have a client who has turtles, and they can live till 200. So there are it's very important if you have those kinds of pets. But I'm a dog person, I'm a cat person. I still think it's important if you have just your standard. I guess golden doodle is probably the most standard dog now. Yes, we get a pet trust. We create a pet trust. You got to think about who you want to take care of your pet, and then we do some sort of incentives there. It's certainly something that be addressed.
That transitions to a question from another viewer. What if I don't have a friend or a relative who is prepared or willing to assume the role of power of attorney or executor?
Yeah, absolutely. We've been discussing this whole time about families and how there can be wonderful situations where you're really lucky and you have somebody who takes care of you, and you can have terrible situations where, nobody's willing to step up to the plate and everybody fights. That's still somebody that's in your family, and some people don't have that at all, right? So there are plenty of ways that you can choose a healthcare proxy or a power of attorney. There are services that you can hire to act as your power of attorney or your healthcare proxy. If you have a trusted financial advisor, you can discuss it with them and see if they'd be willing to be appointed. You can also appoint your attorney as your healthcare proxy or power of attorney. There are some complexities to that and certain requirements that must be met. You just have to know that when you're hiring someone, be it your financial advisor, be it your an outside agency or your attorney, that obviously compensation is required for those things.
And here's another one about speaking to, if one spouse dies, should the other spouse change their deed and add children and remove the deceased spouse's name?
So that's a very specific question. It kind of depends on the situation. When you add people to a deed, you're adding liability to the deed, so it's really something you should sit down and discuss with your attorney, whether that makes sense in your particular situation. But removing a spouse's name from a deed, it can be helpful for purposes of title. Title is, it's people, we just talk about title generally, right? Like title. Title is, it's the process of being sure that you have the ownership over the property and exactly what you think you have ownership over, right? So this particular lot in Garden City is mine, right? And if my fence goes over onto my my neighbor's land a little bit, maybe later it could be mine too. That's a whole other conversation. But nonetheless, it's this, right? So title ensures that that's yours, okay? Title transactions need to be very clear and complete. I had a client come to me who was selling a property in a different state, and they had done a transaction in that state where I guess what happened was their grandmother or great grandmother had passed away, and the siblings were supposed to inherit. Only two inherited, and it was transferred to the two who inherited it, and then eventually, down the line, this is years and years and years ago, it finally comes to us, and so we look at this document, and thank God we ordered title. Because we found out that the transfer for the mom to the two kids, it really never happened in an appropriate manner, right? So it was unclear who had the authority to sell or purchase the property. So for purposes of title, you always want to make a clear transaction history. So you might want to do that, but again, that's something you want to go over with your attorney. You know, in Nassau County, the price to record a deed is very high. It's like close to $1,000. So you really want to think about, you know, what makes sense for your particular situation and what's necessary and what also makes sense financially. We don't want to do anything that's, you know, over the top ever. Okay.
Right, exactly.
Yeah.
And here's a question. It's funny. This one actually happened to me when my father passed away. And I think more and more it happens as people move from one state to another, particularly in this exact case. If the deceased person lives in another state, say Florida, see, I've been there, and the kids are back in New York, how can they go about being the executor of my will?
Right. So the person so in this scenario, the person who died in Florida and was a resident of Florida, right?
Yes, that's what they're asking. Exactly.
All right. So
they've gone down to warmer weather and they left the kids up here.
Yeah. I don't blame them. Sometimes
I don't either.
Warm weather, but right. So you have to engage an attorney, and you're going to have to find that will wherever that will is located. Know where mom and dad keep that will. You need the original in New York, particularly. You know, the original is of the utmost importance. If you don't have it, the likelihood that I can get a copy of it admitted is slim, like extremely slim. So you need to find that original last will and testament. And then you need to petition the court, right? You need to find an attorney who can petition the court in Florida. You know, an attorney in New York can do that for you. It's like a waive-in, but you know, a Florida attorney is probably very useful for that in that particular situation. Now, let's say we have a decedent in New York who also owns property in Florida. You do not have to engage necessarily an attorney in Florida in that situation. The attorney in New York will probably be able to manage things so long as they've done it before. I mean, you know, that's something that we manage here all the time. So many of my clients are snowbirds. So
right.
I wish I was a snowbird, but maybe later.
Exactly. There's a question. What does the term portability mean in estate planning? How does it work?
Yeah, so portability has to do with estate taxes. So the estate tax in New York is like, it's 5.73 or 5.93, sorry, for New York, right? So your estate isn't taxed in 2021 until, if you die in 2021, until your assets are at 5.93 million, okay? At the federal level, this is why I was saying 7 before, it's 11.7 million per individual, okay? Portability has to do with spouses and that estate tax. So let's say Anne and Eric. Eric, you're my little example today. I apologize because I'm going to kill you right now. But Eric, okay, Anne is left. We want to be sure that Anne actually has Eric's estate tax as well added to her estate tax. So what that does is it doubles the value in terms of how high your estate would have to be before it's no longer exempt from the estate tax in New York. So at 5.93 million, we're going to make it easy for me and say 6. It would be $12 million before Eric and Anne's estate is taxed, at least in New York, right? At the federal level, then that means 11.7 and 11.7. So I'm going to say $24 million just for the purposes of not having to do math right now. But you know, portability is ensuring that that tax is then transferred to the surviving spouse, and there's a number of things that you have to do, and you should certainly see your attorney when your spouse dies, because their taxes have to be filed, things like that, to ensure that portability happens. It's very important, right? Because you know, now that estate tax is quite high. I don't know what it's going to be next year. You know, it had been growing and I hope it continues to grow, but who knows? It might stay the same. That would be fine. It might be reduced. You know, about like 15 years ago, it was just $1 million, and on Long Island, $1 million now, you know, most people's homes are close to that. So, that's a huge, completely different situation. So if you're reaching that area of wealth where you have to consider that estate tax, again, we're talking $5.93 million per individual, you better see your attorney ASAP, because things have to be discussed, and we have to talk about ways that we can protect your assets.
Absolutely. And here's a question. So someone has been obviously looking and embracing the idea of planning early. I want to start estate planning early, but when is too early? And what is the danger of giving away my assets while I'm still young?
Right. I mean, while you're still young, there's no, what is young, right?
And I guess young is a relative term. I mean,
Yeah.
if they think they're young, maybe they're in their 20s, or if they're in their 70s and young, good for them.
Yeah, right. Young is so relative. You should certainly have an estate plan. I mean, I've had a will since I was 18. That's the type of person I am, and that's the type of planner I am. And I just change it, as I acquire new things or my life changes. So, if you have a bank account, you should probably have a will, right? If you have an IRA or a 401k, which you might just have from just starting your recent job at 22, it's probably time to make a will. Doesn't mean it needs to be trust, etc. All of these things have to get involved, but you should have a will, because if I don't have a will, we go right with a will, we go through probate. Without a will, I have to go through administration, and that's a much more difficult process and a much more a longer process as well. So it's never too early to have a will. But I mean, if you do, the second you have a home or you have kids and you're married, you should have a will. If you haven't had one yet. That's, if I had to give someone a definitive answer on, when's the time that you should absolutely get one created. Divesting is, it's really an individually specific situation. You're going to want to consider why you would need to. I have clients, and it's really these younger clients, very young actually, in their late 20s, early 30s, who have made so much money from cryptos and things like that, right? So they're seeing me earlier to discuss these things, and to be fair, those kinds of assets are not necessarily stable at the moment, but nonetheless, they're things to talk about. I only have to start divesting and thinking about those things when we're really concerned about taxes, right? And so you have to sit down with your attorney to go over why you might need to divest. Your house, things like that, people are quick to do that. I would really, understand why you needed to. There are always tax implications for divesting, for transferring things to your kids. We talked about the liability aspect of what that could mean. When the house isn't yours anymore, it's not your primary residence. That means, you don't get your star, right? We want our star exemption, our star tax. So, there's a lot of considerations there.
Absolutely. And as we come up upon the hour, one final question here, and this I think ties very nicely back to the beginning of getting started. It says, my mother and father do not want to talk about the idea of them dying. Okay. How do you recommend I can start the conversation so they can start planning? And that's a very real question that I think we've all seen.
Yeah. And also the opposite, right? The kids don't want to hear it. They don't want to even think about mom or dad dying. I think that the best way to address those things is to say, I want to make sure that everything's okay when you're gone. And I want to start getting things in order, because I'm going to be sad when you're gone, mom and dad. And I don't want to have to worry about, transferring this and getting all of that done. I just want to make sure that I can grieve for you and then handle things appropriately. And hopefully that'll get them, to discuss it. Otherwise, you got your work cut out for you.
Exactly right. Well, I want to thank you, Stephanie, so much for all the great conversation, the great information, the incredible insights. It's really been a true pleasure. I want to thank our entire audience out there for everything they've sent in and for really being a part of this conversation. It's ongoing. And as Stephanie and I have said, it's about learning all the way, right?
Yes. Thank you so much, Eric. I really appreciate you having me. And it was great to speak to everybody who attended. Thanks for attending.
Absolutely. Again, thank you to D'Angelo Law Associates VC for being our sponsor here today. We look forward to everyone in our audience out there going to liherald.com to learn more about upcoming webinars, and we'll see you all again soon.